they promulgated a new rule limiting workers' access inside the facility for any time period greater than 30 minutes prior to and after their shift. This rule is not in their policy handbook and violates status quo under the law.
Which side are you on? Which side are you on?
Starbucks is not the only company breaking the law and illegally interfering with their workers' right to form a union. Amazon is as well. The union has filed 3 charges against Amazon. RWDSU, the union that the workers at Amazon have decided that they want to affiliate with. RWDSU, the retail, wholesale, and department store union, have filed 3 charges against Amazon. From their press release, the first 2 are a ULP for an unfair labor practice, that's what ULP stands for the removal of union literature from break rooms. They say that Bamazon Union Worker Organizing Committee members have been posting pro-union literature in non-work areas on non-working time alongside anti-union postings from the company. The Bamazon Union flyers were removed by Amazon in violation of the law. The law states that in neutral areas where there is the ability to post for workers to post things, or where the company is posting anti-union propaganda, the workers have the right to post their own flyers, their own literature. That's the law. Amazon is violating it. They also filed a ULP, an unfair labor practice, against Amazon for the promulgating of a new rule. You'll remember that tracks with what the Starbucks Workers United, with what they filed their ULP for, because of the new rule about how much you have to be available to work for Starbucks to work there. At Amazon, they promulgated a new rule limiting workers' access inside the facility for any time period greater than 30 minutes prior to and after their shift. This rule is not in their policy handbook and violates status quo under the law. So what is status quo? Status quo says that you can't, the law is basically that you cannot, in response to workers organizing in your facility, you cannot create out of whole cloth a new rule or begin implementing a rule that had not been implemented before in response to workers organizing. Amazon in Bessemer has created a new rule out of whole cloth that says that workers cannot stay inside the facility for any time period greater than 30 minutes prior to and after their shift. That is obviously, it's not in their handbook, so this new rule is obviously aimed at hampering worker conversations, at hampering union organizing. It's illegal. The third is a bit different. It's very interesting. They call this one potentially precedent setting. They are challenging the legal right of employers to hold captive audience meetings at all. Section 7, from their press release, Section 7 of the National Labor Relations Act guarantees employees, quote, the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection, as well as the right to, quote, refrain from any or all such activities. When workers are forced to attend required meetings, the union says, during work hours to hear the company's anti-union propaganda, that violates their right to refrain from any and all such activities. I think that's a good argument. This unfair labor practice charges that Amazon is in violation of Section 8A1 and or 8A3 of the National Labor Relations Act and seeks to challenge the current yet often challenged case law precedent, which has for too long allowed employers to compel attendance to anti-union meetings. These aptly named captive audience meetings are coercive, and workers should have the right, as is already protected under the law in Section 8, to not engage in them. The union can't force workers to attend union meetings because of the law. They have the right to refrain from activities like that. They should also have the right to refrain from activities that are against the union from the company. The ULP charge seeks to remedy via review of this law by the newly seated National Labor Relations Board. They do this following a memorandum from the NLRB General Counsel requesting workers pursue cases like this. So we are hopeful that this will win. And if it does win, that's going to be huge because so many workers, I took off work last week and spent all last week knocking on doors of Amazon workers. And there are so many of these people. I mean, not so many. The workers have been able to reach most of the people by now. But there are people who the workers have not been able to talk to about the union. And I could tell in my conversations with some of these people that they had only heard the company side of the argument, and they took it as gospel, basically. And so they asked me questions that were clearly informed by anti-union propaganda from the company. And so I either told them how and why it's wrong, or I recontextualized it to make sure that they have the full context of what Amazon is saying. And every time I did that, they said, wow, Amazon didn't tell us that. That doesn't sound so bad. Wow, they didn't tell us that part. Oh, I didn't know that. Because in these mandatory anti-union captive audience meetings, they're not telling workers the full truth. They're not giving them the full context of everything that they're talking about. They are only spouting the company line with everything else taken from it. And so I was talking to a worker last week who asked me how to talk to people who have been informed by this stuff, this kind of stuff. And, I said that we do have one advantage on our side, which is that all we have to do is tell the truth. All that we've got to do is tell the truth.
That's right.
And the company doesn't have that advantage. So,
the attorneys of Maples, Tucker, and Jacobs are proud to represent working people in Alabama and across the Southeast. They have over 100 years of experience representing injured workers in workers' compensation, personal injury, and disability claims. Let their attorneys help you when you get injured on the job. You can find them at www.mtandj.com or 855-617-9333. Let Maples, Tucker, and Jacobs help you when you get injured on the job. Again, the website is www.mtandj.com or the phone number 855-617-9333. No representation is made that the quality of legal services is greater than the quality of legal services from other law firms.